Welcome to the Unity Forum, a cross-partisan program dedicated to fostering reasoned discourse and a more open society. In each episode, we talk with well-established experts to provide insight on recent events, elevate civil dialogue, and encourage greater mutual understanding on social, economic, and legal issues. Our host is Chris Malone, founder of Pendulum Group and author of the award-winning book, The Human Brand: How We Relate to People, Products, and Companies.
Welcome and hello. I'm Chris Malone and I'll be your host for today's discussion. Thanks so much for joining us. Our guest today is Professor Stephen Wermiel, a nationally recognized expert on constitutional law, the U.S. Supreme Court, and First Amendment rights. He serves as professor of practice at American University, Washington College of Law, where he teaches constitutional law, First Amendment law, and a seminar on the Supreme Court. Professor Wermiel is also the co-author of Justice Brennan, Liberal Champion, the definitive biography of one of the most influential justices in modern Supreme Court history. Earlier in his career, he served as a Supreme Court reporter for the Wall Street Journal, covering more than 1,300 decisions over 12 years. He's a prolific scholar and advocate for civic education. Professor Wermiel is also a fellow in the law school's Marshall Brennan Constitutional Literacy Project and a regular contributor to SCOTUS blog. His insights into the court's inner workings and the evolving landscape of constitutional law are respected across the political spectrum. Professor Wermiel, welcome to the Unity Forum.
Thank you so much, Chris. It's a pleasure to be here.
Pleasure to have you. So let's start with the big picture. There have been quite a few executive orders come out of the White House during the past year. How should we think about these? What are the key constitutional guardrails that define what are the limits of executive power in the United States?
Well, we have a variety of guardrails. Separation of powers in the Constitution is one of them, where the branches all have a check on each other. Congress can check the president, the Supreme Court can check Congress and the president. They're not necessarily working because the president has taken a very broad view of the scope of his power, including ways in which he doesn't think Congress needs to be involved in many of his decisions. The other effect of the president's actions is to eliminate some of the external guardrails. He's gone after universities, he's gone after law firms, he's gone after the news media. And while those entities don't play any formal role in our government or in the Constitution, they often serve as a kind of external, informal check on government power. And I think the president has neutralized those to some extent as well.
And so should we think of these kind of guardrails as kind of norms that are this is the way we've traditionally done it? Or are these firm posts that say, hey, this is the way it has to be done in our country?
A little bit of both.
Okay.
I think the constitutional ones, the separation of powers and the checks and balances among the three branches are more than norms. They are long-standing understandings of how the Constitution works and how the branches are supposed to interact with each other. And those understandings are being defied in current day. I think the external guardrails are more informal norms that don't have to exist. They have existed for a long time, but they're not written down anywhere.
Got it. Well, there's a lot been going on, particularly in the last week, relating to military force. And when U.S. forces are engaged in battle internationally and abroad, we're hearing a lot of references to things like the War Powers Act, and Congress can only authorize war. But on the other hand, we hear that, hey, that has not been very frequently introduced or invoked or what have you in recent years. I wonder if you could kind of give us some history of the War Powers Act, the context it came out of, and how it has worked in theory and in practice over the years.
Sure. So I suppose it's something of a cliche to say we're in a constitutional moment here, but we are. Um, the Article 1 of the Constitution says Congress shall have the power to declare war. Article 2 of the Constitution says the president is commander in chief. It is thought by many, me included, that the framers in 1787 believed that committing military forces or weapons to conflict would require action by both Congress and the president, that it was such an important, weighty kind of decision that it should involve both branches. Um, we haven't actually declared war since World War II. And if you read the language of Article 1 literally, Congress has the power to declare war, then one way of thinking, and I think this is the president's way of thinking, is, well, if we're not declaring war, then Congress has no role to play, and I'm commander in chief, so I'm going to do what I think I need to do. That effectively shuts out Congress and gives Congress no say in these kinds of decisions. And so that's the constitutional moment we're at. This didn't just crop up, as a brand new issue. Because we haven't declared war since World War II, we have faced this question on a number of occasions. What was the authority for the Vietnam War? Venezuela a couple of weeks ago, Iraq a couple of decades ago. We've confronted this issue over and over. The critical question is, will Congress do something to assert its role in this process? And by asserting it, I don't mean that they have to attack the president. The Democrats in Congress are certainly very critical of the president's action here, but there's still a Republican majority in both houses. And Congress, if it wanted to, could pass a resolution supporting the president's action in Iran. But in so doing, would be saying, you need to have our approval, and we're giving it to you. But nevertheless asserting that you don't get to shut us out of this process, that we have a role to play, and that that's what the Constitution intended.
Got it. And so it sounds as though you're saying that the Constitution intended for both arms of government to play a role in that, and that over time there have been varying ways that that has played out.
I mean, James Madison, going all the way back, even said, presidents may have a natural inclination to want to go to war, and that's why we made it a power that required congressional input as well. So we've been playing at this stalemate, if you will, since the start of the Korean War.
Mm-hmm.
Korean War was a little different because we joined a multinational force. But ever since the Korean War, every engagement of military action by the United States has not been with the declaration of war. Congress has stepped in various ways. If you remember that after 9/11, Congress, after a few months, passed something called the Authorization for the Use of Military Force, which justified the war in Iraq, and eventually Afghanistan. That wasn't exactly following the dictates of the law, but it was close enough that I think it satisfied everybody that Congress had its say. But that hasn't been the case in subsequent situations.
Got it. And so if Congress passed a resolution either for or against current military action, would that resolve the constitutional questions at hand, or not necessarily?
Well, again, there's sort of two issues there. One is, are we paying respect to the structure of the Constitution? And two is, does it make a difference as to what's happening in Iran?
Mm-hmm.
So as to the first one, I would argue that yes, that would kind of honor the shared authority over military engagement that the Constitution envisioned. What Congress does obviously would determine whether it has any impact on what's happening in Iran. If Congress passed a resolution under what's called the War Powers Act, which was passed back in 1973. It was vetoed by Richard Nixon, but it was approved by Congress over the president's veto. Um, the War Powers Act gives the Congress the power to order the president to withdraw the troops within 60 days of the commitment, and then gives the president a certain amount of time to do that. I don't think we've ever actually invoked that provision, but that was passed by Congress specifically to get Congress back in the game, to get Congress back in the action so that they would have a role to play.
Got it. Let's shift our attention a little bit to the Supreme Court. There's been a consequential Supreme Court decision recently regarding President Trump's tariffs and international trade negotiations. In your view, is this decision a signal that the court might broadly limit the executive branch efforts to set tariffs without Congress, or do you think this is more of kind of a temporary reprieve, as seems to be suggested by Justice Kavanaugh's dissenting opinion?
The oldest joke in legal education is that the answer to every question is it depends.
Hmm.
And I think it depends.
Okay.
Let's talk about tariffs specifically first, and then maybe broaden the question. What the court did in the tariffs case, although it obviously has enormous worldwide implications, was actually a very narrow thing that the court does all the time. It looks at the language of a statute passed by Congress, and it says, here's what we understand that statute to mean. In this instance, by a 6-3 vote, we don't see anywhere in the language of that law, that specific law, that gives the president the power to impose tariffs. He's ordering new rounds of tariffs, but using different laws. And so the court's view of what authority the president had under the International Emergency, whatever it is, Economic Powers Act, IEEPA, is not necessarily going to carry over to the language of other statutes. Each case is going to be different. The court is going to interpret the new tariffs under the language of different laws than the one it's already interpreted. So I don't read necessarily a message from the court that there's no power in any law for the president to impose tariffs. I think that will remain to be seen. What the court did say, and very briefly, because it wasn't the central issue in the case, is that there's no inherent power in the Constitution for the president to impose tariffs. He's going to have to find some authority in a federal law, and that's what he's in the process of currently doing. On the broader sort of version of that question, was this decision a sign that the court is not going to keep ruling in Trump's favor as it has in emergency cases? Again, not necessarily. I think the fact that the court found that Trump had violated the law here or misread the law here is an important sign that they're not just automatically ruling in his favor, but there are several more important Trump-related cases that the court is going to decide still this spring, and it remains to be seen how those come out. So I don't think this is a broader signal yet. It could turn into that, but I think at the moment we're sort of going case by case.
Fair enough. You mentioned some of the other emergency decisions that the court has made, and we have seen over the past year kind of expanded assertions of executive authority in areas such as immigration enforcement, federal funding allocation. You mentioned higher education, and college and university independence, and so forth. What constraints exist from a constitutional standpoint on executive power in those instances? Are there things that are clear, or is it again a depends type situation?
I mean, I have to say that I think there are things that are clear and that are clearly being ignored. Um, and I think the president is proud of it, frankly. There are, for example, there should be constraints on the president's ability to either not spend funds that Congress ordered be spent, or to shift those funds to other places and other expenditures. There's law on both of those situations, and the president is basically taking the position that that's not binding on him, that once the money is available, he can choose not to spend it or to reallocate it in certain situations. Um, I think that's contrary to the Constitution and contrary to the will of Congress. But I think he's pushing those limits. Immigration, he has enormous authority. When Congress passed the first major immigration law, the Immigration and Nationality Act, it basically gave the president very broad discretion over immigration law and policy. In addition, numerous presidents in recent decades have said, we don't just have the authority that Congress gave us in that law, but because we're the head of state, we're the head of foreign policy for the United States, that gives us inherent immigration authority as well. So in that realm, numerous presidents have claimed kind of a double whammy. We have the authority Congress gave us as well as our own inherent constitutional power. Going after the universities and threatening them, seems to be a stretch as to his constitutional authority. Closing down branches of the federal government would seem to be something that Congress should have to have a say in. Attacking law firms because he doesn't like the cases they've handled in the past doesn't seem to be within any obvious presidential authority. But if he intimidates them and they cave in and agree to do what he says, then there's no issue. Several law firms have stood up to him and have won federal district court rulings in their favor. And so it goes. I mean, I think he's redefining the powers of the presidency in his own mold.
Yeah. Now, as we kind of look as observers at all of this unfolding, and we read in the news that states of California or Illinois or Minnesota have challenged in federal court actions by the Immigration and Customs Enforcement, or the challenges to cuts in federal funding in certain areas or deportations or what have you. And we see on some cases, federal court judges overturn those actions and then they're appealed and then they're re-implemented. How should we think about this? We might have thought that the rule of law was more of a black and white thing, and we see it kind of going both ways here. How should we feel or interpret when we see that happening? Is that something that should concern us? Is it simply partisan politics at play, or have the rules changed in some way?
It's a very good question, and there's not a simple answer. One way to think about this is that the role of the Supreme Court and the role of federal district courts may be two different things in the process we're talking about. But first, a couple of observations. The president has now been sued by some estimates over his policies more than 700 times in a year. I mean, that's an astounding statistic. It's partly a multiplier of the number of policies he's implemented. He has lost in federal district courts maybe as many as 200 times. Federal district judges have ordered him to stop particular policies as many as 200 times, and that is also extraordinary. The federal judges in those instances are trying to make their best assessment of what the current state of the law is and what it currently requires. I don't think it's fair to assume that they're all being partisan, although the president assumes that. I think federal judges, for the most part, are very conscientious and try hard to find the right result. Many of those orders have gone to the Supreme Court on an emergency basis, what's come to be known as the shadow docket. Those are instances in which the Supreme Court's not being asked to rule on whether the president violated the Constitution or violated a federal law. The Supreme Court is asked to rule on what should happen in the meantime while those cases are moving through the lower courts. My view is that the Supreme Court has taken the position that unless we're actually ruling on the legality or constitutionality of the president's actions, he's the president, he has broad authority, and we're going to defer fairly broadly to his power. Not necessarily when we get to the merits of the cases, but on this procedural shadow docket, we'll defer to him until we get around to the merits. That leads to a lot of confusion. It looks like the Supreme Court is banging the heads of federal district court judges, and the federal district court judges have expressed frustration. There have been a number of important stories where some federal judges anonymously, not only disagreed with Trump, but disagreed with the Supreme Court in the way it's handling their ruling. So it's a kind of fraught situation, and it's one that I think is understandably very confusing to people.
Right. I wonder, what are the rights of states under circumstances, whether it's the ICE enforcement in Minneapolis or a National Guard troop deployment in Portland or California or what have you? Do governors and states have the right to resist these things, or is that clear in any way?
They don't really have a clear right to resist. Once the president asserts that he's federalizing the National Guard, which he has the legal authority to do, or if he's sending ICE into states where he says they're enforcing federal immigration law, they don't really have obvious right to refuse. But there's a couple of problems there. One is, as with the war in Iran, where the goal of what we're trying to do there seems to be changing, there's a problem with the president's assertions for sending ICE in different places. Right? Ostensibly, what he's supposed to be doing is enforcing immigration law and maybe using ICE and or the National Guard to keep federal officials, the ICE forces, and federal buildings safe in particular locations. That makes a certain amount of sense and is probably within some degree of his authority. But if you listen carefully, every time he talks about this, he talks about how much safer he's made each of these cities. Well, that's not part of his authority for using ICE or the National Guard. He doesn't really have a legal authority to send the National Guard in as local law enforcement. So is he protecting federal entities, legitimate, or is he trying to stop crime in cities? Maybe a worthy goal, but not necessarily legitimately part of his power. And that's a major dichotomy that I think exists.
Yeah. How should we think about upcoming elections? Now, I believe in the Constitution and other laws, the power to conduct voting and things of that nature lies with the states, and those are then reported to the federal government and so forth. As the fall elections approach and President Trump starts to talk about implementing further requirements for voter eligibility and things like that, where do states' rights begin or end versus federal rights begin and end?
I mean, the federal government doesn't have a lot of authority over how the states run the elections, whether it's the midterms or the presidential election. The Constitution says the states shall determine the times, places, and manners of holding elections. it says subject to such rules as Congress may determine, but it doesn't give the president any real power to suspend elections, to alter elections. I think he likes to scare people. And I think he's doing that somewhat successfully by making it sound like, oh, he might decide to cancel the elections or send the National Guard or send ICE to polling places. I don't think that he has a lot of authority to interfere. That hasn't necessarily stopped him in other contexts.
To what extent should we think of the Constitution as either protecting or not protecting the independence of institutions like the Federal Reserve or the Department of Justice from political influence and interference? Is that spelled out in any significant way or more unclear?
Not spelled out so much in the Constitution. It is spelled out in some federal laws and by longstanding tradition. The Federal Reserve Board is both federal law and longstanding tradition. There is some amount of evidence that when the Federal Reserve Board was formed, Congress thought that the monetary policy ought to be set once or more removed from the political process, and that would be good for the economy and good for the sort of objectivity of monetary policy. The Justice Department is more by tradition. We have a long history, breached occasionally, that the Justice Department is not really an arm of the president, that the Justice Department is supposed to force the laws at some political arm's length or political distance. That was a problem in Watergate, in the Nixon administration. Conservatives will say, are you kidding? How about John Kennedy appointing his brother Robert Kennedy to be Attorney General? I don't think that's proof that he didn't keep the Justice Department at arm's length, but there's certainly an argument to be made there. The President Trump and Attorney General Bondi seem to want to kind of hold hands as they waltz down the path of criminal prosecution and enforcement of the laws, and say we're in this together, and there is no kind of arm's length separation.
Got it. Now, I know that you've been an advocate for civic education, and I'm wondering what you think is the role of civic understanding of constitutional law in helping preserve our democracy. Do we as citizens have a role to play in that? And does our knowledge of these things matter in your view?
I think it's very critical and essential. I think one of the unfortunate things that has happened in our country over recent decades is that civics is not taught as much as it once was, and is kind of short-circuited when it is taught. So, I now teach law students constitutional law, so they've gone through 4 years of college, and this is now their first year of graduate school, and I still find I have to explain some core civics concepts that are not widely known or understood. I think it's critical that people understand how the government works and how it's supposed to work, and what the Constitution's expectations are. And I think we're not doing a good enough job of that. And I think that contributes to some of the division in the country and some of the polarization we face, as well as some of the concerns about the future of our democracy.
Yeah. So we're obviously in what will likely be a divisive election year later this year. In your view, what should Americans watch for, whether it's legally or constitutionally, to stay informed and engaged as we navigate all this together?
Well, I don't know why, as a country, we have so much trouble with the fundamental concept of voting. It's a pretty foundational idea. You're a citizen, you're registered, you get to vote, period. We seem to have more trouble with it than countries that are not nearly as democratic as we are. So that to me is one of the things we ought to be watching for. I don't know the truth of the allegations yesterday in the Texas primaries, but there was some suggestion that when they redistricted one of the Texas congressional districts, they moved all the polling places, but they didn't tell anybody. This isn't a game. You have a right to vote, and that means you ought to be able to vote. Having a right to vote and not being able to figure out how to do it is not the way this is supposed to work. So I would look for whether people are meaningfully able to exercise the right to vote. And if not, then we need to be doing something about it.
Good advice. Now let's take a few questions from those listening remotely. We do have a question from Harris Contos. He asks, let's get down to brass tacks. Are any specific ideologues from the Federalist Society and the Heritage Foundation identifiable as they not only stretch but break the legal rubber bands? I'm hoping that question is clearer to you than it is to me.
I don't know if there are specific individuals to point at. The Heritage Foundation clearly did the 2025 Project 2025 report.
I see.
And while the president said he had no knowledge of it and wasn't involved in it, much of his agenda is at least, I won't say comes from, because I don't have that knowledge, but is at least tracking a lot of what was in that conservative document. The Federalist Society has provided some of the ideological underpinnings for what Trump and the courts and Congress are saying. One of the key things that's happening today is what's called the concept of the unitary executive. The unitary executive is the notion that really all power resides in the president, and that the president ought to be able to exercise his powers to the maximum extent possible. That's an idea that's been pushed by the Federalist Society for many years and other conservative think tanks. But I don't have the information to point fingers at particular individuals. Certainly those entities have influenced the MAGA movement and have influenced what's happening in the Trump administration.
Okay, that's helpful. Here's another question from Dr. Stephanie Almaden. Is there any clarity in the Constitution to protect the democracy when elections yield majority results for one side or the other, canceling the checks and balances logic that we all took pride in? What would stop a totalitarian regime then?
Well, I thank you for the question, and my answer is going to be very unsatisfying, which is the only recourse we have is to vote. And this goes back to what I was talking about at the outset of our conversation about the role of Congress in the war. If you have a Congress that doesn't care enough about its own authority outlined in the Constitution to want to assert that authority, then no, we really don't have a lot of recourse.
Because that's really our representation, essentially. And if they are not representing us, then that's where the buck stops, I imagine.
Right. And again, I think Congress could assert itself without infuriating the president. I understand that many of them are afraid of getting primary challenges, at the behest of the president. But stand up and say, this is our role. We're asserting our role, but we're approving of what you do. That would be better than the nothing that they are currently doing. And at least it would be Congress saying, you have to recognize our authority, even if we're not going to disagree with your specific policy.
Right. Because if that arm of government isn't acting in any way, what are they there for? I suppose if they're there to play a check and balance role relative to the other branches in some form.
And I mean, that ought to be nonpartisan, right? I mean, the Republicans in Congress should care about that as much as the Democrats. But there's no evidence that they do.
Okay. Now, as we kind of bring this to a close, for those of us who might be feeling kind of disillusioned or powerless, what closing thoughts of hope or inspiration might you offer to us who still believe in the founder's model of a constitutional democracy?
Well, I could try a couple things. I spent a long time with the late Justice William Brennan of the Supreme Court. He was very generous with his time and access to his papers when I was working on his biography. And one of the things he always told me was he believed that the interpretation of the Constitution was a pendulum. And as I was talking to him, it was swinging away from him. But he believed not in his lifetime, but believed sincerely that the pendulum would swing back and that that was the nature of our democracy. Now, for people who are impatient, that's not a lot of encouragement because obviously the pendulum is moving slowly and probably still moving away from Justice Brennan's direction. So when it will swing back, I don't really know. I think that people have to just keep believing in our Constitution, believing in our democracy, trying to educate friends and neighbors and family about separation of powers, about core democratic principles, voting, trying to get other people to vote, trying to object to interference with the right to vote. Um, it's one thing to say non-citizens can't vote and you think there's fraud and that dead people and non-citizens are voting, but there's no real evidence of that. President Trump has never proven any evidence of that. Um, and so trying to make sure that everybody who is entitled to vote gets out and votes. Educating our young people about civics, as we discussed. I think those are all things respecting peaceful protests. If I can tell one quick story, we had a group at the American University Law School where I teach. We have a conference space that they lease out from time to time. They leased it out to an organization last week that invited Clarence Thomas to come speak. And so the word got out that Clarence Thomas was coming, and some of our students decided they were going to stage a peaceful protest. Um, Clarence Thomas then announced to the world that there was a threat against him and that he couldn't come speak at our law school and that he would have to speak on Zoom. In all candor, I have no knowledge of whether there was actually a threat against him, but there was definitely a peaceful protest against him, and that's protected by the First Amendment. He went into the New York Times and gave a whole interview about the trouble of incivility in our society. And I share that concern. But a peaceful protest against his views is not incivility. In fact, I would argue that it's civility. It's part of our democracy. So that lesson to me is also critically important. Let's respect the ability of people to express their views in appropriate ways.
We just got a late question from Rebecca Pomerantz. It a little bit speaks to this. I just wonder if there's anything you would add. She asked, could you say more about what needs to be taught or is missing from public's understanding that causes our current divisiveness? Anything to add to the comments you just made?
I'm a big First Amendment buff. I believe deeply in the broadest views of free speech. It's not always acceptable to everybody in our society. Our notion of free speech protects a lot of speech that people find offensive. But a core principle of our free speech is that we don't want the government to be deciding where to draw that line because that's censorship. So if we have to put up with controversial speech in order to not have the government deciding what we can and can't say, I think that's a critical principle and that's not taught. That's not understood in junior high school civics or high school civics or even on college campuses in many places. And that's not a partisan, liberal political correctness is just as repressive as conservative ideological purity. We need to be able to talk to each other, and that needs to be taught.
I think that is a fitting final thought. that we really need to be able to talk to one another. And kind of the purpose of this program is to bring us together, to have those conversations and find common ground and better understand where each of us is coming from. So, Stephen, I can't thank you enough for such a thought-provoking and insightful conversation. It's been a real pleasure talking with you. I'd like to thank all of our listeners as well for their time and thoughtful questions. And be sure to join us for another episode of the Unity Forum. We'll be exploring more thought-provoking insights and issues with well-established experts. Until then, thank you and have a great rest of your day.
Thanks for listening today. If you enjoyed this episode of the Unity Forum, please give it a rating, share it with others, and join us on Facebook at Alumni for Freedom and Democracy. And be sure to join us next time for another thought-provoking discussion on the big ideas shaping our collective future.